Right now, a wildfire of misinformation is spreading across social media about the Second Amendment. The headlines scream, "Supreme Court just destroyed gun rights," or 8-to-1 decision changes everything. But here's what's actually happening. Most people sharing these posts have no idea what the case was really about, what the court actually said, or how narrow this ruling really is. And that ignorance, that's dangerous. Not politically dangerous. Legally dangerous, the kind of dangerous that shows up in arrest reports and courtroom moments where people say, "I didn't know it worked like that." Before we break down what really happened in United States v. Rahimi, subscribe to Capital Prime and turn on notifications. This is exactly the kind of Supreme Court decision where the gap between the headline and the reality can cost you your rights. Hit that subscribe button now. Let me show you what the court actually said and what it didn't. United States v. Rahimi. Strip away the politics, the viral tweets, the rage posts, and the clickbait thumbnails. The legal question was actually very simple. Can the federal government temporarily stop someone from possessing firearms if that person is under a domestic violence restraining order? And a court has formally found that the person is a credible threat to someone else's physical safety. The Supreme Court answered yes, 8-to-1. Not a close call, not a shaky compromise. 8 justices agreed. If a judge makes a legal finding that you are a real danger to another person, the government can temporarily disarm you while that court order is active, and doing so does not automatically violate the Second Amendment. That's the holding. That's the reality. Now let me show you why. What the court didn't say is far more important than what it did. Pay attention. This is critical. The court did not erase the Second Amendment. The court did not say accusations are enough. The court did not approve broad permanent gun confiscation. The court did not approve broad permanent gun confiscation. Rahimi is narrow, painfully narrow. It applies to a specific legal situation involving a specific kind of court order issued through a process that includes findings and procedures. This is not red flag laws can do whatever they want. This is not the government can disarm anyone they don't like. This is if a judge, through a formal legal process, finds you are a credible threat to someone's physical safety, you can be temporarily disarmed while that order is active. That's it. That's the scope. But here's where people mess up. They hear temporary and think safe. They hear civil order and think no big deal. They hear not criminal and relax. That's how people fall through cracks they didn't even know existed. Let me show you how this actually plays out. Meet Mike. Mike has never been convicted of a crime. He owns firearms legally. He follows the rules. He's the guy who thinks laws apply to other people. Then Mike goes through a breakup. It's emotional. It's messy. Words are exchanged that shouldn't have been. One day, Mike gets served with paperwork, a protective order request. Mike doesn't panic. He rolls his eyes. This is family court drama, he thinks. It's not criminal. It's temporary. It'll blow over. That moment right there is where futures quietly collapse. Because if that protective order includes a credible threat finding, federal law snaps into place suddenly. If Mike possesses a firearm while that order is active, he could be committing a federal felony. Not because he shot anyone, not because he threatened someone with a gun, but because he underestimated a piece of paper. Temporary orders can produce permanent consequences. That's not fear-mongering. That's how the system works. Now, here's the question everyone asks. How can the Supreme Court say this and still claim the Second Amendment exists? Here's the answer most people don't want to hear but need to. Even the strongest pro-Second Amendment decisions have always said the right is not unlimited. Not unlimited does not mean meaningless. It means regulated in extreme situations. In Rahimi, the court explained that American law has always allowed the government to intervene when someone posed a real threat of violence. Historically, there were laws designed to stop people who terrorized others or threatened harm with weapons. The court's reasoning was simple. If you are a genuine danger, society has always had tools to step in, and temporary disarmament fits that tradition, This isn't new constitutional theory. This is the court applying the framework from District of Columbia v. Heller, 2008, and New York State Rifle and Pistol Association, Bruin, 2022. Bruin established that gun regulations must be consistent with America's historical tradition of firearm regulation. Rahimi said, disarming dangerous people, that's part of the tradition. Pay attention to this next part because it tells you how serious this decision really is. Rahimi was decided 8-1. That's not a close call. That's not a fragile majority. That's near unanimity. Only Justice Clarence Thomas dissented. That signals something important. This is not an extreme ruling. It's a stabilizing one. Even the court's most conservative justices, Alito, Gorsuch, Kavanaugh, Barrett, joined the majority. Why? Because the law at issue wasn't some broad, vague power grab. It was narrow, procedurally protected, and rooted in historical practice. Here's another detail people keep missing. Rahimi was a facial challenge. That means the defendant argued the law was unconstitutional in every possible situation. That is the hardest constitutional argument to win. The court didn't say the law is always valid forever in all circumstances. It said the law is clearly valid in situations like this, one where there's a formal judicial finding of danger. That's a huge difference. It leaves the door open for future challenges in specific cases where the law might be applied unconstitutionally. Now let's talk about the part of the viral headlines that pulls in the First Amendment, because this is where confusion really explodes. Rahimi itself was not a First Amendment case. The First Amendment issue comes from a separate Supreme Court fight, but it hits the gun world in a way most people underestimate. Here's the issue stripped down. The government cannot secretly pressure private companies to punish speech it doesn't like. That includes gun speech, gun advocacy, gun organizations, gun-related businesses. Why does this matter? Because modern power doesn't always come with handcuffs. Sometimes it comes with phone calls, with suggestions, with regulators quietly reminding companies who controls their licenses. And suddenly, banks stop working with you, payment processors drop you, insurance disappears, platforms vanish. No law passed, no vote taken. But speech gets suffocated. This is what happened with Operation Choke Point during the Obama administration, where federal regulators pressured banks to cut ties with gun dealers and other high-risk businesses. And there are allegations it's happening again, what critics call Choke Point 2.0, with gun businesses being debanked, deplatformed, and financially strangled without formal legal proceedings. That's why the First Amendment side of this story matters so much to gun owners, because the Second Amendment cannot survive if the First Amendment is quietly choked off. If you can't speak, if you can't organize, if you can't fund legal challenges, then the right exists only on paper. So when people say both amendments changed, the smart interpretation is this. The Supreme Court clarified how courts must judge certain gun laws under the Second Amendment. At the same time, it reinforced limits on how far the government can go when pressuring speech under the First Amendment. Two different battles. One shared battlefield. Now let's bring this back to you. What actually changed in your life today? Here's the reality. If you are a gun owner, you have more to lose than most people in moments of conflict. That means you have to be calmer, more boring, more careful. Because the law does not forgive mistakes involving firearms the way it forgives other mistakes. Most people don't lose rights in dramatic moments. They lose them in boring ones. A court date skipped, a message sent in anger, a form not read carefully, a restraining order treated like gossip. The law doesn't care how good you usually are. It cares what's written, what's filed, and what you did next. Let me give you the actual law at issue here, because specifics matter. 18 U.S.C. Section 1922, G8 prohibits firearm possession by anyone subject to a qualifying restraining order. To qualify, the order must be issued after a hearing where the person had notice and opportunity to participate, restrain the person from harassing, stalking, or threatening an intimate partner or child, include a finding that the person represents a credible threat to physical safety, or again, explicitly prohibit the use of physical force. If all three conditions are met, possessing a firearm is a federal felony punishable by up to 10 years in prison. This isn't a state misdemeanor. This is federal time. And here's the kicker. You can violate this law even if you never knew the order had those specific findings. Ignorance is not a defense. So here's what you need to know if you're ever served with a protective order. 1, take it seriously immediately. Don't roll your eyes. Don't dismiss it as drama. 2, get a lawyer before the hearing. Not after, before. Your gun rights may be on the line, even if no criminal charges are filed. 3, understand what findings the court is making. Ask your lawyer, will this order trigger 922 GEFQE? If yes, you must immediately surrender or transfer your firearm. 4, don't possess firearms while the order is active. Not at home, not in your car, not just this once. Federal law doesn't care about your reasons. 5, document everything. If you lawfully transfer your firearms, keep records. If the order expires, get confirmation in writing. Rahimi is not the end of the Second Amendment, and it's not proof that nothing is changing. It's a warning light. Rights are real. Government power has limits, but ignorance is expensive. The court said if you're a proven danger through a formal legal process, you can be temporarily disarmed. That's constitutional. What the court did not say, the government can disarm anyone, anytime, for any reason. The gap between those two statements is where your rights live or die. If you only remember one thing from this video, remember this: precision protects you. Emotion exposes you. Don't rely on viral headlines. Don't rely on internet bravado. And don't assume temporary means safe. The Supreme Court just clarified the rules. 8. 1. United States v. Rahimi. Domestic violence restraining orders can temporarily disarm someone found to be a credible threat. The Second Amendment still exists, but it's not unlimited. It never was. Subscribe to Capital Prime for legal analysis that cuts through the noise. Hit the notification bell. And tell me in the comments, did you understand what Rahimi actually said before this video? Stay informed, stay calm, stay smart. This is Capital Prime. We'll keep watching.